Nobody likes to think about passing away, but if you have money, assets, or anyone who depends on you, estate planning is essential. Without it, the state decides what happens to your estate, and it might not be what you would have wanted. This is one of those topics that people avoid until it's too late. Don't make that mistake. Estate planning sounds complicated and morbid, but it doesn't have to be. At its core, estate planning is about making sure your money and assets go where you want them to go, when you want them to, and to the people you want to have them. Let's cover the basics that everyone should understand, regardless of how much money you have. Every solid estate plan starts with a few key documents. First is the will. A will is a legal document that tells your executor how to distribute your assets after you die. Without a will, the state decides who gets what, which might not match your wishes. If you have children, a will is especially important because you can name who will take care of them if something happens to you. Without a will, the state makes that decision. Second is the durable power of attorney. This document names someone you trust to make financial decisions for you if you become incapacitated. Without it, your family might have to go to court to get the authority to manage your affairs, which is expensive, time-consuming, and stressful. Third is the healthcare directive, also called a living will. This tells your medical team what types of care you want or don't want if you can't communicate your wishes. It also lets you name someone to make healthcare decisions for you if you can't make them yourself. These three documents form the foundation of any estate plan. They're not just for the wealthy, they're for anyone who wants to protect their family. The biggest estate planning mistake is simply not having any plan at all. People think estate planning is only for the wealthy, but that's simply not true. If you have any assets at all, a basic estate plan ensures they go where you want. Let me give you a real example. A single person dies without a will. The state distributes their assets to their closest relatives. If they have no close relatives, the state keeps everything. That's probably not what the person would have wanted. Another common mistake is creating a plan and then never updating it. Life changes, like marriages, divorces, births, and deaths, all require updates to your estate plan. An estate plan from 20 years ago probably doesn't reflect your current wishes or family situation. For some people, a trust makes more sense than a will. A trust is a legal arrangement where one person holds assets for the benefit of another. Trusts can help avoid probate, which is the court process that happens after someone dies. Assets in a trust can be distributed immediately without going through probate, which can save time and money. Probate can take months or even years, and it can be expensive, with attorney fees and court costs. Trusts also offer more control over how and when assets are distributed. For example, you might want to leave money to your children, but not give them complete access until they're older and more responsible. You can set up a trust that holds the money and gives them access at certain ages or for certain purposes. There are different types of trusts, and each serves different purposes. Revocable trusts can be changed during your lifetime, while irrevocable trusts generally cannot be changed once created. The right type depends on your specific goals and situation. One thing that many people overlook is beneficiary designations. These are incredibly important and often override what your will says. Retirement accounts like 401k accounts and traditional IRA, as have beneficiary designations. Life insurance policies have beneficiary designations. Bank accounts can have payable on death designations. When you die, these assets go directly to the named beneficiaries, regardless of what your will says. This is why it's crucial to review your beneficiary designations regularly, especially after major life events like marriages, divorces, or deaths. I see people all the time whose ex-spouse is still listed as their beneficiary, even years after the divorce. That person would get the money, not whoever they'd want to have it now. One more thing to consider: your digital life. In today's world, we all have online accounts, digital photos, and cryptocurrency. Your estate plan should address what happens to these digital assets. You can include digital asset instructions in your will, or create a separate digital asset memorandum. Make sure someone you trust knows how to access your accounts and what you'd want done with your digital presence. The cost of estate planning is relatively small compared to the potential problems of not having a plan. A basic estate plan with a will, power of attorney, and healthcare directive might cost $1,000 to $3,000, depending on where you live and how complex your situation is. But the cost of not planning can be much higher. Your family might end up in court, fighting over assets. They might have to pay attorney fees and court costs from your estate, and they might not get what you would have wanted them to have. Estate planning isn't about death. It's about taking care of the living. It's about making sure your family is protected, your wishes are respected, and your hard-earned assets go where you want them to go. The best time to create an estate plan was yesterday. The second best time is today. Don't wait until it's too late. If this was helpful, hit that like button and drop a comment below. What's your biggest estate planning question? I'd love to hear what's on your mind. And if you want more content like this, subscribe. I share exactly what I wish I knew so you can make smarter money moves.